Oh, hello. Welcome to my bar review show. Today we're talking about criminal law and criminal procedure. We're going to specifically talk about criminal procedure. It involves the Fourth Amendment, Fifth Amendment, Sixth Amendment, pre-trial, trial, and post-trial. Fourth Amendment involves general principles, arrest, and search and seizure. General principles involve standing, exclusionary rule, government conduct, and reasonable privacy expectation. Standing. Defendant must have standing to assert claim. This means defendant himself has been seized, or defendant has reasonable privacy expectation regarding place searched or item seized. Exclusionary rule. It prevents unlawfully seized evidence's intro at subsequent criminal trial. It does not apply to federal habeas corpus review, grand jury proceedings, preliminary or bail or sentencing hearings, proceedings to revoke parole, evidence used as impeachment evidence against defendant, or civil proceedings. Judge makes suppression decisions. Factual findings are reviewed for clear error, while law findings are reviewed de novo. Government conduct. Is public paid police, police directed by private person, or deputized private police? Reasonable privacy expectation. As to place searched, for example, a bathroom, or item seized, example, toast. All right, arrest. Unreasonable seizure of persons. We've got seizure, stop and frisk, warrant, and warrantless address. Seizure. When police, by physical force or show of authority, terminate or restrain movement freedom and defendant actually submits. Totality of the circumstances. If police intent to restrain is ambiguous, or if defendant's submission is only passive acquiescence, then seizure occurs if totality of the circumstances will lead an innocent, reasonable person to believe he's not free to leave. Unreasonable seizure of persons. Stop and frisk. Temporary detention that constitutes seizure if officer, by physical force or show of authority, has in some way restrained, physical restraint or order to stop, citizen's liberty. Temporary detention that constitutes seizure if officer has in some way restrained citizen's liberty. Warrant. Arrest. Must be issued by detached or neutral magistrate on probable cause finding and describe with particularity defendant and crime. Deficient warrant does not invalidate arrest as long as probable cause existed. No warrant is required for proper probable cause-based arrest. Search. Issued by detached or neutral magistrate on probable cause finding, supported by an oath or affidavit, and must describe with particularity the places to be searched and the items to be seized. There has to be a reasonable belief that contraband will be found. Facts supporting probable cause. Officer's personal observations. Info from reliable known informant or verified unknown informant. Evidence seized during stop and based on reasonable suspicion, discovered in plain view or during a consensual search. Particularity. Must specify place to be searched and objects to be seized. Can also refer to contraband as other fruits, instrumentalities, or evidence of crime at this time unknown, and still be valid. Knock and announce. Police must generally announce their purpose when executing a warrant, unless state allows exception for exigent circumstances. A violation does not trigger the exclusionary rule. Warrantless address. Arrest warrant is not needed in a public place or for felony or misdemeanor in arresting party's presence, but an invalid arrest alone is not a defense to crime charged, but will affect any seizure of evidence. In determining whether crime has been committed, question is whether officer could conclude, considering all the surrounding circumstances, substantial chance of criminal activity existed. Search and seizure. It involves government conduct, reasonable privacy expectation, search warrant requirement exceptions, standing to object, exclusionary rule, and harmless error. Government conduct. Search must be by government employee or agent. Reasonable privacy expectation. Involves home, private room or office, luggage, automobiles, open areas, odor from car, and tech device. Home, private room or office. Home and curtilage, motel rooms, and businesses are protected. Drug sniffing dog use is search if physically intrudes onto constitutionally protected property. Luggage. Reasonable privacy expectation for invasive searches, but not for canine sniff. Autos. Need reasonable law violation suspicion to effectuate stop and probable cause for pretextual stops when traffic law is violated to investigate whether another law has been violated. Fact, person, and rental car's lawful possession is not listed on rental agreement does not defeat his reasonable privacy expectation. Open areas. Outside curtilage, no reasonable objective privacy expectation exists. Odor from car, no reasonable privacy expectation. Tech device. Attaching tracking device to person without consent is search. Collecting cell site location info from wireless carrier to track person requires a warrant. Physically intruding on suspect's property to install a tech device may be search. Use of sense-enhancing devices not used by general public is search. Search warrant requirement exceptions. Generally, you do need a warrant, but here are the exceptions to that rule. Search incident to lawful arrest, exigent circumstances, stop and frisk, auto exception, plain view doctrine, consent, and warrant authorizing wiretapping. Search incident to lawful arrest must be reasonable in scope and incident to lawful arrest. Wingspan includes contemporaneous search of person or immediate surrounding area, including pockets and containers. Does not include cell or laptop unless exigent circumstances exist. Home. Protective sweep is permissible even without probable cause or reasonable suspicion. Includes places immediately adjoining arrest place in home. Includes places immediately adjoining arrest place and home from which attack could be launched and in which person may be hiding, like adjacent rooms, closets, or showers. Search area can be broadened if based on reasonable suspicion others are hiding beyond these immediately adjacent areas. Vehicle. Justified if arrestee is within reaching distance of passenger compartment during search or is reasonable evidence of offense of arrest might be in vehicle. Exigent circumstances. Totality of the circumstances test. Must have probable cause and exigent circumstances. Police may not create exigency by threats or conduct that violate the Fourth Amendment. Hot pursuit. Police and suspects' pursuit can seize mere evidence, not crimes, fruits, or instrumentalities from a private building if police have probable cause to believe suspect committed felony. Emergency. reasonable apprehension. Delayed warrant would result in immediate danger of evidence destruction, police or public safety, or fleeing felon, judged by police objective reasonable belief. Stop and frisk. Stop, Terry stop. Reasonable suspicion, circumstances totality based on articulable facts. Detainee was involved in criminal activity and is limited to or temporary intrusion on defendant's freedom of movement. Frisk. Officer without probable cause may pat down person's outer clothing if officer has reasonable suspicion suspect was or is involved in criminal activity, and frisk is necessary for safety. Under plain feel exception, if officer conducting valid frisk feels object whose ID is immediately obvious, then object can be seized. Passenger compartment. Permitted if police have reasonable belief suspect is dangerous and may get immediate control of weapons, and search is limited to places where weapon could be hidden. Limitations. Least intrusive means reasonably available to frisk for weapons only, but if suspicion becomes probable cause, then officer can make arrest and conduct a full search. Auto exception. Can search any car part like compartments, particular containers including luggage, trunk, etc. if probable cause that particular car area contains contraband or evidence of crime, does not permit warrantless entry of home or curtilage to search vehicle therein. Plain view doctrine. In public view, there's no reasonable privacy expectation. In private view, officer on premises for lawful purpose. Items incriminating nature is immediately apparent. Officer has lawful access to item. Consent. Voluntary. No threats of harm, compulsion, or false assertion of lawful authority. Circumstances totality. But government agent may pretend to be someone else. Third party. Can consent to own property search, but defendant's property only if agency relationship to defendant or defendant assumes risk of search when giving right to third party to consent to search. Warrant authorizing wiretapping. Limited time period. Probable cause specific crime has been or is about to be committed. IDs persons and describes particular conversations to be tapped. Direct when terminate. You have to say when you're going to terminate the tapping and reveal the intercepted conversation to the court. Standing to object. Defendant must show a legitimate privacy concern with regard to search. Exclusionary rule. Poisonous trees fruit. Applies not only to evidence initially seized as a result of government illegality, but also to the secondary derivative evidence resulting from the primary taint. Exceptions. Inevitable discovery, independent source, attenuation, good faith, isolated police negligence, knock and announce, and in-court ID. Inevitable discovery, in same condition through lawful means. Independent source, unrelated to tainted evidence. Attenuation, time's passage and or intervening events may purge primary taint. Good faith, applies to police relying in objective good faith on either facially valid warrant later found invalid, or existing law later held unconstitutional. Does not apply if no reasonable officer would rely on the affidavit underlying the warrant. Warrant is defective on its face. Warrant was obtained by fraud. Magistrate wholly abandons judicial role, or warrant improperly executed. Isolated police negligence. Not enough to trigger exclusionary rule. Must be sufficiently deliberate that exclusion can meaningfully deter it. Knock and announce. Exclusionary rule does not apply when police fail to knock and announce their presence. In-court ID. Not unlawful detention's fruit. Harmless error. Court can refuse to order new trial if error harmless beyond a reasonable doubt. Illegal evidence did not contribute to result. All right, we made it through the first part. Let's take a big, huge break. You can pause the video here and come back when you like. Fifth Amendment involves privilege against compulsory self-incrimination. Fifth Amendment in police interrogation context. Tainted confessions fruits. And Fifth Amendment in a trial context. Privilege against compulsory self-incrimination. The rule. No person shall be compelled in a criminal case to testify against himself. Applies to states through the 14th Amendment. Testimonial evidence. Non-testimonial physical evidence like blood, urine, breathalyzer, etc. is not protected. Extra. Privilege against self-incrimination extends only to compelled testimonial communications. So though act like being forced to speak in a lineup may provide incriminating evidence, a criminal subject may be compelled to make a voice recording. Proceedings. Applies to civil or criminal, formal or informal proceedings if answers provide reasonable possibility of incriminating defendant in future criminal proceeding. Waiving privilege. Defendant waives by taking stand and answering prosecution's questions. Witness waives by disclosing self-incriminating info in response to specific question. Immunity. Prosecution may compel incriminating testimony if prosecution grants immunity. Transactional. Blanket or total immunity fully protects the witness from future prosecution for crimes related to testimony. Use and derivative use only precludes use of witness's own testimony. Immunity precludes use by another U.S. jurisdiction to prosecute defendant. Extra. Any police attempt to directly elicit incriminating statements violates defendant's right to have counsel present during interrogation, including through an informant's use while defendant was in his cell. Fifth Amendment in a police interrogation context. Any incriminating statement obtained from custodial interrogation may not be used against suspect at subsequent trial unless police inform subject of Miranda rights. We've got custodial interrogation and compliance. Custodial interrogation. Custodial. Substantial seizure, formal arrest or freedom restraint equivalent to arrest. Would a reasonable person believe he could leave? Questioning at police station is not automatically custodial. Interrogation. Questions, words, or actions reasonably likely to elicit incriminating response. Voluntary statements are not protected. Confessions are involuntary only if coerced by police. Circumstances totality. Compliance. Content or timing. Warning must be given before interrogation begins, or given again if stopped for a long time. Need not be verbatim, but must inform suspect of right to remain silent. Any statement can be used in court, and right to attorney, or one will be appointed. Counsel right. Suspect must make specific, unambiguous statement asserting his desire to have counsel present, and once invoked, All interrogation must stop until counsel is present, unless suspect voluntarily initiates communication with police, including spontaneous statements, or 14-day or more break in custody and fresh Miranda warnings are given. Right to silence. Suspect must make specific unambiguous statement asserting desire to remain silent. Mere silence is not enough. Interrogator must scrupulously honor right if invoked, but if suspect indicates a desire to speak, subsequent interrogation is lawful if suspect is not coerced, and Miranda warnings must be given again. Exceptions. Public safety, routine booking questions, and undercover police. Waiver. Suspect must knowingly, voluntarily, and intelligently waive right. Silence is insufficient. Tainted confessions fruits. Miranda violation doesn't automatically result in suppression of incriminating statements made after second warning is given. But second confession is inadmissible if circumstance makes it clear police approach was intentional attempt to circumvent Miranda. Fifth Amendment in a trial context. Defendant can refuse to testify at criminal trial or other proceeding. Defendant can refuse to testify at criminal trial or other proceeding that might incriminate him in future criminal proceedings. Witness may also invoke Fifth Amendment privilege, but may raise Confrontation Clause issues if partial testimony was already given. All right, we got another big break. You can pause the video here and come back when you like. Sixth Amendment. It gives the defendant the right to a jury, public trial, confront witness against him, cross-examine witnesses, be present at his own trial, and counsel's assistance for his defense. We've got applicability, counsel right, offense specific, counsel denial remedies, and ineffective counsel assistance. Applicability, counsel right, proceedings types, any case where actual or suspended incarceration is imposed. Applicability, automatically applies at all critical prosecution stages after formal proceedings begin, and right automatically attaches when formal judicial proceeding has begun. There's no counsel right at a post-conviction proceeding. A formal judicial proceeding could be post-arrest initial appearance before a judicial officer, a formal charge, preliminary hearing, indictment, information, or arraignment. You would get the Sixth Amendment counsel right there. A post-conviction proceeding would be things like parole or probation. You don't have a counsel right at those things. Waiver must be voluntary, knowing, and intelligent. Receiving Miranda warnings sufficiently apprises a person of his Sixth Amendment rights, as well as the consequences of waiving those rights. Subsequent waivers. If accused actually asserts his counsel right, then subsequent waivers are presumed involuntary, but only in custodial setting. If accused has not actually asserted his counsel right, then no presumption exists that any subsequent counsel right waiver will be involuntary. Even after Sixth Amendment rights attach, police may initiate a non-custodial interaction with accused outside of attorney's presence, and there will be no presumption any knowing waiver of right to have counsel present for interaction is involuntary. Right to proceed pro se. Defendant can refuse counsel and proceed pro se at trial. Court should warn defendant of the dangers and the disadvantages and may appoint a standby counsel. Defendant may be competent to stand trial, yet incompetent to represent himself. Withholding information. Police have no obligation to inform defendant counsel has been trying to reach him, unless Sixth Amendment has attached. Offense specific. Blockberger test. 2 different crimes in one criminal transaction is deemed same offense unless each offense requires proof of an element that the other does not. Miranda comparison. Unlike Miranda, counsel's presence only applies to interrogations about offense charged, and police must deliberately elicit incriminating statement to create a violation. Like Miranda, defendant may make knowing or voluntary waiver of right. Counsel denial remedies. Effect of conviction. Defendant's conviction is automatically reversed even without specific unfairness showing. Effect on guilty plea. Defendant has right to withdraw it, and withdrawal cannot be used against defendant as an admission. Non-trial proceeding. Harmless error analysis. Defendant statements to informants. Post-indictment statement to informant where situation is likely to induce defendant to incriminate himself without counsel is inadmissible, but police may put informant in defendant's cell to listen without questioning defendant. Poisonous exclusionary rule. Poisonous tree's fruit applies to statements and physical evidence obtained as a result of violation. Such evidence will be inadmissible. Impeachment. Incriminating evidence obtained in the Sixth Amendment's violation may be used for impeachment. Ineffective counsel assistance. Reasonable competence is presumed. To prove ineffective, claimant must show counsel's rep fell below objective standard of reasonableness and counsel's deficient performance prejudiced defendant, resulting in reasonable probability outcome would have been different. Mere inexperience, strategy, or failure to produce mitigating evidence is insufficient. Prejudice is presumed if deficient performance cost defendant appeal, even if defendant signed waiver of his right to appeal as part of the guilty plea. Conflict of interest. Reps of defendants with conflicting interest may amount to ineffective assistance of counsel. Must show actual conflict and adverse effect on counsel's performance. Actual conflict. This occurs when court determines defense attorney is subject to obligation or unique personal interest that, if followed, would lead him to adopt strategy other than the one most favorable to the defendant. Adverse impact. Occurs when plausible alternative strategy or tactic might have been pursued but was inherently in conflict with or not undertaken due to attorney's other loyalties or interests. And we're done with the Fourth Amendment, Fifth Amendment, and Sixth Amendment. Let's take a big, huge break. You can pause the video here and come back when you like. All right, let's talk pretrial. It involves eyewitness ID procedures, preliminary proceedings, right to bail, competency, grand juries, and state's duty to disclose. Eyewitness ID procedures. We've got types, Sixth Amendment counsel right at a lineup, and impermissibly suggestive ID procedures. Types, corporeal, in person, this would be lineups. Non-corporeal, not in person, photo arrays. Sixth Amendment counsel right at lineup. You have it at an in-person post-indictment lineup, but not at a non-corporeal photo array. ID is inadmissible if violated, if the Sixth Amendment right to counsel is violated, but witness can ID defendant at trial if the ID has an independent reliability. Impermissibly suggestive ID procedures. There's a two-pronged test. Defendant must prove ID was impermissibly suggestive, and substantial mis-ID likelihood exists. Prosecution may prove ID was nonetheless reliable. Prosecution may prove that the ID was nonetheless reliable. Opportunity to view, attention degree, witness description's accuracy, certainty level, and time length. Remedy, suppression hearing, outside jury's presence to determine admissibility. Impermissibly suggestive procedures finding results. Impermissibly suggestive procedures finding results in suppression. Preliminary proceedings. Probable cause to detain must be held within 48 hours of arrest to determine probable cause. Fourth Amendment guarantees defendant right to be released if no probable cause. No remedy if detention is unlawful, other than evidence's exclusion. Initial appearance. Judge will advise defendant of charges and rights and appoint counsel if defendant is poor. Judge may decide bail conditions and accept plea. Right to bail. No constitutional right to bail, but denial of or excessive bail must comply with due process clause. Competency. Defendant must comprehend nature of proceedings against him and have ability to consult with lawyer with reasonable degree of rational understanding to be competent to stand trial. Grand juries. Defendant has no right to present or confront witnesses or introduce evidence, and no dismissal due to procedural defect unless substantial impact on decision to indict. So basically, you can do almost anything in the grand jury room. Intentional racial discrimination in grand juror selection results in convictions overturned. State's duty to disclose. Affirmative duty to disclose to defendant any material evidence favorable to defendant and relevant to prosecution's case in chief that would negate guilt or diminish culpability or punishment. Failure is grounds for reversal if defendant shows evidence is favorable to defendant and failure to disclose caused prejudice against defendant. All right, pre-trial is expired. Let's take a big, huge break. You can pause the video here and come back when you like. All right, trial involves jury trial, guilty pleas, speedy trial, fair trial, right to confrontation, due process, sentencing, and finally, cruel and unusual punishment. Jury trial involves federal, state, presence, length, waiver, and jury. Federal, Sixth Amendment right to federal jury trial. State. Under 14th Amendment, defendant has state jury trial right in criminal cases for non-petty offenses. Presence. Defendant has right, with some exceptions, to be present at initial arraignments, every trial stage, and sentencing. Length. Right attaches for non-petty offenses regardless of actual penalty imposed. Waiver. Defendant can waive jury trial right and opt for judge trial by obtaining court's approval and freely or intelligently entering a voluntary waiver. Jury. 12 members unless. FRCP requires 12 members unless waived in writing and approved by court. But verdict by 11 is permitted if 12th juror is excused for good cause after deliberations begin. Fewer than 6. In state courts, juries of fewer than 6 jurors are unconstitutional. Unanimous verdict. Unanimous verdict is constitutionally required of both federal and state juries, regardless of the number of jurors. Cross-section. Jury pool must rep cross-section of community, but actual jury selected need not. Defendant can challenge selection process without showing of actual bias. Standing. Defendant can challenge selection process without showing of actual bias. Prima facie case. Absence of representative cross-section requires. Distinctive group is excluded, for example, no flamingos. Group is not fairly represented in the jury pool, and underrepresentation resulted from group systematic exclusion. Neutral principles. In response to intentional racial discrimination in jury selection claim, state can use neutral or non-racial principles and must prove discriminatory intent's absence. Preemptory challenge. Discriminatory use. 14th Amendment prohibits challenges solely based on race, ethnicity, or gender. Moving party must establish prima facie discrimination case. Party who exercise preemptory challenge must provide race-neutral explanation. Moving party's burden to prove other party's reason was pretextual. Challenge loss. Does not violate impartial jury right. Harmless error. State can choose between harmless error review or automatic reversal when judge in good faith erroneously denies defendant's preemptory challenge. Impartiality. Accused is entitled to trial by impartial jury, and juror bias or misconduct claims are subject to harmless error rule. Race. Court must allow defendant to question potential jury members' race views when case involves race prejudice or when race is inextricably bound up in case. Capital punishment. Death penalty opposed jurors can be removed for cause if opposition substantially impairs duties during sentencing. Sentencing enhancement. Judges' sentencing enhancement for reasons other than defendant's prior conviction, absent jury determination of existence of additional facts, violates defendant's jury trial right. Medium break. Guilty pleas. We've got knowing involuntary, counsel right, plea bargain, and effect on defendant's rights. Knowing involuntary. Must be intelligent and voluntary and made in judge's presence. Judge must advise defendant and determine plea is not due to force or promises other than the ones in the plea agreement. Under federal rules, judge must determine some factual basis for plea exists. Counsel right. Defendant has counsel right when entering a plea. Plea bargain. Defendant has no constitutional right to plea bargain. Plea made in response to prosecutor's threat to bring more serious charges does not violate the Due Process Clause. Prosecutor is not required to disclose impeachment info or info related to affirmative defense. Enforcement. Plea bargain is enforceable against prosecutor and defendant, but not judge. Judge can reject the plea. If prosecutor violates bargain, judge can decide whether or not to order bargain-specific performance or whether defendant can withdraw the plea. If defendant violates the bargain, prosecutor can have sentence vacated and reinstate the original charges. Effect on defendant's rights. Defendant can attack plea for counsel's ineffective assistance, jurisdiction lack, or due process violation. Medium break. Speedy trial. Due process clause. Protects pre-accusation delay and statute of limitations as primary safeguard. Sixth Amendment. Protects post-accusation delay and time period starts at arrest time or formal charge. Three-part balancing test. We've got delays, length, and reason, defendant's rights assertion, and prejudice to defendant. Remedy. Dismissal of charges with prejudice. Medium break. Fair trial. Impartial judge. No actual or apparent bias is permitted. Prosecutor. Cannot misstate a law or a fact, talk to defendant without counsel present, express opinion about defendant's guilt or innocence, make improper remarks about defendant, or comment on defendant's failure to testify. Break. Right to confrontation. We've got trial, face-to-face, confrontation clause and hearsay rule, and finally confessions admission, the Burton rule. Trial. Accused has right to encounter and cross-examine adverse witnesses and be present at any trial stage. Face-to-face. It's not an absolute right. It may be prevented for public policy reasons. Confrontation clause and hearsay rule. Testimonial out-of-court statements by witnesses generally are barred under confrontation clause unless witnesses are unavailable and defendant had prior opportunity to cross-examine those witnesses, or if witness is unavailable because defendant acted with purpose to prevent witness from testifying. Out-of-court testimonial statements are not confrontation clause barred when used for purpose other than establishing the truth of the matter asserted. Testimonial statements. Declarant would reasonably expect statement to be used in prosecution. Non-testimonial statements. Statements made for primary purpose of assisting police in investigation of ongoing emergency are not testimonial. Confessions admission, the Burton rule. Confessions admission by non-testifying co-defendant at joint trial against defendant violates the Sixth Amendment. Break. Due process. Permissive presumption. Permissive presumption regarding offense element is not due process violation because the state still has to convince the jury, unless it is irrational. Mandatory presumption is a per se violation. Reasonable doubt. Prosecution must prove all elements beyond a reasonable doubt. State may give defendant burden to prove affirmative defense. Insanity, self-defense, entrapment, duress. Court may acquit if insufficient evidence exists for jury to reasonably find defendant guilty. Break. Sentencing. Applicable rights. Right to counsel, confront, and cross-examine. Any fact other than prior conviction that can be used to increase statutorily prescribed maximum must be charged in the indictment, submitted to jury, and established beyond a reasonable doubt. Break. Cruel and unusual punishment. Non-death penalty. Prisoner must show prison officials had actual knowledge of substantial risk to prisoners or serious injury, or sentence was grossly disproportionate to the crime. Capital punishment can only be imposed under statute that provides clear or objective standards, specific detailed guidance. Sorry, I'm going to try this one all over again. Capital punishment can only be imposed under statute that provides clear or objective standards, specific or detailed guidance, and opportunity for rational review of process. All right, we finished it up. Let's take a big break. You can pause the video here and come back when you like. Post-trial involves double jeopardy, appeal, and convictions. Double jeopardy protects against second prosecution for same offense after acquittal or conviction and against multiple punishments for same offense. Protects against second prosecution for same offense after acquittal or conviction and against multiple punishments for the same offense. Same offense. Blockberger test applied if defendant's conduct can be prosecuted as two or more crimes. So, Blockberger test generally bars successive prosecutions for greater or lesser included offenses unless jeopardy attaches to less included offense before an event necessary for greater offense. Attachment. When jury is impaneled or sworn in, or when first witness is sworn in for a bench trial. Different jurisdictions. Defendant can be charged or convicted in federal and state court. Civil actions. Not precluded by criminal punishment for same conduct. Guilty plea. Not automatically waived. Collateral estoppel. Applies when earlier decision must have necessarily determined issue on which collateral estoppel is sought by defendant. All right, moving on to appeal. First appeal as of right. Defendant is guaranteed equal protection and right to counsel, but attorney may withdraw and there is no right to self-representation. Discretionary appeal. Indigent defendant does not have right to counsel unless conviction was based on guilty or nolo contendere plea. Errors must timely preserve. Generally, errors must be timely preserved for consideration on appeal. Harmless error. Error doesn't affect substantial rights. A harmless error won't serve as reversal grounds. Plain error. Defendant who failed to preserve error claim is entitled to appellate relief when district court committed error under law in effect at time appeal is heard, error is obvious under that law, and error affected defendant's substantial rights. Convictions. Defendant can attach conviction after unsuccessful appeal under habeas corpus writ. It's a civil action, so the standard is an evidence preponderance. The court will apply two tests. Unlawful detention had substantial and injurious effect or influence on verdict, and court's decision was contrary to law or based on unreasonable determination. And we're done. Congratulations, you made it through criminal procedure. We'll see you on the next video.